Research Methods Screencast Ethical and Legal Issues by Charlie Taylor. So firstly, we're going to go through what BASIS stands for. It stands for British Association of Sport and Exercise Science, and their role is to govern sports and exercise research to make sure that the research that is being done is legally and ethically conducted. To help make sure of this, they produce a code of conduct which makes sure that the researcher who's doing the study doesn't break any rules. The definition of legal is when something is allowed by the law, and the definition of ethical is the difference between wrong and right, such as morals. There are two ethical and legal issues in sport and exercise science, which are an informed consent form and confidentiality. So firstly, I'm going to talk about the informed consent form. This is one that I have done as an example. This is a form which a participant signs to show that they have agreed to take part in the study and that they know what is going to happen during it. It also tells them that they are able to leave at any point if they start to feel uncomfortable. An example of when an informed consent form is used illegally is when the procedure uses a different substance to what is said on the form. For example, a consent form could state that the client is going to be tested on EPO drugs. However, in the real thing, they are put on stimulants, and the punishment for this crime could be a ban for life for the researcher. An advantage of using an informed consent form is that the participant is able to feel more safe while taking part in the study. This is because they know that the procedure is more likely to match what is said on the consent form, meaning that more people are willing to sign up for the test because they know that there is a low risk of them getting scammed by being told one thing and being put through another. Also, another benefit of using an informed consent form is that it discourages researchers from conducting tests illegally, because they know that they'd get badly punished if they did anything illegally, and this will reduce the cases of participants being mistreated and will encourage researchers to be honest. The second ethical and legal issue is confidentiality. Confidentiality is there to ensure that only information relevant to the investigation can be given to the public. For instance, names should never be allowed to be released. However, the gender and age of the participant is. This is because gender and age might be a reason for why the result has come out in a certain way. Researchers can use codes to refer to clients so that they don't have to say the names. For example, name them Participant A, Participant B, or Participant C. And this is to make sure that the confidentiality is achieved. The Data Protection Act was made in 1998, and this states that all data must be securely stored in a locked filing cabinet or cupboard. Moreover, only relevant personnel are allowed to access the information. A way of dealing with confidentiality issues is with tribunals. A tribunal is a court of justice organised and run by BASIS, and researchers will be put on trial. These trials would be needed if the confidentiality code was broken. For example, this could happen if a participant finds out that a researcher shared their personal information. An advantage of a tribunal is that we are able to trust that research is being done in the right way. This will result in more people looking into the research and listening to it, meaning that the company will get more funding and recognition. Contrary to this, a disadvantage of a tribunal is that it can take a long time to get going. This could put people off from getting justice because they may not want to wait a really long time for something they aren't guaranteed to get justice from. Another disadvantage is that tribunals cost a lot of money, meaning that those with a smaller budget would have less of a chance to find justice because they won't be able to fund a good campaign and that is able to meet the defence. A further disadvantage of a tribunal is that a well-funded defence could prevent a guilty researcher from being found guilty. This stops people who deserve justice from getting any compensation because their opposing defence has stopped them from being found mistreated by the offender. Lastly, a tribunal could see a researcher with no wrong intentions being found guilty of their previous research, and if their previous research was to be claimed unethical. This stops the researchers sharing what they have found because they are legally prohibited from sharing or using that information. This could also result in the researcher being banned for life, meaning that they won't be able to contribute to future studies. The last way of dealing with a legal research method is through measures to prevent future research. Examples of these include punishment and bans to try and deter illegal behaviour. The seriousness of a punishment will rely on the initial crime committed. For example, this is required when a client who has expressed that they have an injury to a certain area, and the researcher ignores that and causes them to further injure themselves. This could get a researcher banned for life. The first advantage of this method is that it helps clients feel more secure around the researcher, knowing that they will not put us in any danger. This would reduce the chances of the client feeling more uncomfortable and wanting to leave, and that means that the researcher is more likely to get the information that they need. The final advantage is that it can make those affected feel like they have got some compensation for what they have been through, meaning that they feel happier and gives them satisfaction over the situation, which allows them to move on. Contrary to this, one of the disadvantages of the measures to prevent future research is that a world-class researcher could get banned if they unintentionally use equipment that is not correctly maintained, meaning that one of their clients could get injured. This would eliminate one of the best researchers from the business, meaning that we would miss out on some findings due to them not being allowed to conduct their research. The next disadvantage of this method is that a fine has the potential to not impact big companies. For example, if Adidas was to cause an injury to one of their clients due to not maintaining their equipment correctly, they may only be fined £15,000, which will not impact the big company, but because they'll be able to afford it, meaning that they won't be deterred from doing it again. The final disadvantage is that a researcher is not guaranteed to stop conducting illegally after coming back from a suspension. This means that a number of cases where researchers mistreat clients would not go down, causing the research world to become safer, which would discourage participants from investing their time into research, and that causes less findings to be found.